Is there any chance we can get people to move a little bit forward?
Yeah, exactly. So I just don't move each one.
I know, I can already see.
Oh, here we go. This is great.
Good morning, everybody, and thank you for coming. Welcome to the first annual conference for the Duke Forum for Law and Social Change. I'm Monique McNellie. I'm one of the managing editors, and this is Melvin Hines, our editor-in-chief. Today's conference is sponsored in part by the Education, Law, and Policy Society here at Duke, by Weil, Gotchel, and Manges, by the Career Service Center, and by DBA, the Duke Bar Association. I just wanted to take a moment and talk a little bit about our organization because it's very new and we're very excited that it's here and it exists today at Duke. We began the process of starting this organization a couple of years ago because we felt that there was an empty niche here at Duke that needed to be filled. And we basically wanted an organization that was going to focus on social issues and bring them to the forefront of the Duke community and give them attention and basically allow discussion to revolve around them. So we hope today to engage in a lot of discussion. We hope that everybody will participate and have a great time. Today's conference is called Moving Education Forward, and it's on perspectives and innovation in education, law, and policy. And welcome.
Good morning, everyone. My name is Melvin Hines, and I just wanted to give you guys a little bit of a background on our conference today. Last April, we had a Brown panel called Remembering Brown, which featured some prominent people in history, specifically the Brown versus Board of Education decision. Judge Lewis Pollock, historian John Hope Franklin, and Professor Jack Greenberg were all on our panel. It was moderated by Professor Guy Charles, and it was a very enlightening discussion which discussed what went into creating Brown, and as well as looking forward, what should we expect and what do they think that we should expect. Especially as law students, we felt that this was especially important. And continuing with this discussion, we are having our conference today, as Monique so eloquently put. It's called Moving Education Forward, Perspectives and Innovations in Education, Law, and Policy. Without wasting any further time, I just want to move really quickly through what will be happening today, and then turn it over to Julia German, who will be introducing our first panel. Today we'll first begin with a panel discussion called Does Integration Matter? It's at 10 o'clock, which is what time it is now, featuring Professor Olatunde Johnson, Kristi Bowman, and Professor Wendy Scott. Like I said, hosted by Julia German, and moderated by Professor Jim Coleman. We will then have breakout sessions at 11:10. There will be 3 breakout sessions. The first one, breakout session A, will be Careers in Education and the Law, sponsored by Career Services. Our second breakout session will be a student note presentation featuring our very own Sonia Ralston-Elder, called The Time Is Now, Enforcing a State Right to Education Through a Private Right of Action. And our third breakout session will be a community discussion sponsored by or hosted by the Black Law Student Association, South Asian Law Student Association, and the Women's Law Student Association. We'll then have a keynote luncheon featuring President Rufus Williams and sponsored by the Duke Education Law and Policy Society. This will be in Birdman Lounge, which is room 3000. It may be a little bit hard to find. Just ask any one of us and we'll be more than happy to show you where the room 3000 is. At the end, we'll have a second panel discussion titled Issues and Innovations in Legal Education. The participants will be Professor John Garvey, Professor Irene Ayers, and Professor Andy Curcio. And it will again be moderated by Professor James Coleman. And our student host for that event will be Maynora Eltari. After that, we'll have a reception, which will be in the, on the third floor, and we'll conclude our event. Thank you once again for coming, and I now turn it over to Julia German.
I know you're excited to get to the panel, so I'll make this introduction brief. I'm Julia German. I'm one of the two article editors for the forum. And I'm pleased to introduce today our moderator, Jim Coleman. Professor Coleman's been a full-time faculty at Duke since 1996. He's an expert in criminal law, and he also teaches the Wrongful Convictions Clinic and the Appellate Litigation Clinic. He's certainly a favorite among our professors, and we're happy to have him helping us out today. We also have on our panel Professor Wendy Scott. She is a professor at North Carolina Central University, and she's the author of a new strategy for pursuing racial and ethnic equality in public schools. She received her BA at Harvard and her JD at NYU. She's a nationally recognized expert on race law and constitutional law. She's worked at the Legal Action Center in New York City, privately for a union, labor, and plaintiff employment discrimination firm, and at the Center for Law and Social Justice. She has been a professor and a dean at various universities, Tulane Law School, Hunter College, Brooklyn, and CUNY. And we're pleased to welcome her today. Our second panelist is Olatunde Johnson. She's a professor at Columbia University and the author of Does Integration Still Matter?, which is the title of this panel. She's an expert in anti-discrimination law, constitutional law, civil procedure, administrative law, congressional power, and public interest law and practice. She received her BA at Yale University, her JD at Stanford Law. Notably, she clerked for Judge Sattel of the U.S. Court of Appeals in D.C., in the D.C. Circuit, and for Justice Stevens of the Supreme Court. She's also been employed by the NCAA Legal Defense Fund, the U.S. Senate Judiciary Committee, ACLU National Legal Department as a senior counsel on racial justice. And so we are very pleased to have her here as well. And finally, Professor Kristi Bowman is a professor at Michigan State University. She's the author of From Desegregation to Diversity Jurisprudence. She received her JD here at Duke, and it was a JD MA. And her BA before that came from Drake University. She's an expert at property law and education law, and has been a professor at the universities of Mississippi, at Drake, and I believe now is a professor at Michigan State, as I mentioned. And notably has also had clients, she's had school districts as her clients and has worked for the U.S. Department of Education in the Civil Rights Office. Thank you all for being here, and I hope that you enjoy the panel. Here's Professor Coleman.
Okay,
Thank you.
okay. Melvin, I said after, guy. I have a very limited role here, thank goodness, and it is to keep track of the time primarily, but also to tell you how we're going to proceed. The order in which the three panelists will make their presentations is that Professor Scott will go first, Professor Johnson, and then Professor Bowman. What we'll do, and they will each will speak for somewhere between 8 and 10 minutes, and then what we will do is to give each of them 1 to 2 minutes to respond to anything that the other panelists say in their presentations, and then we'll open it up to you to ask questions. And what we hope happens here is that you become engaged in a lively discussion centered around the question of whether integration still matters. So, Professor Scott.
Good morning, everyone. It's a pleasure to be here, and I'm honored to have been asked to place an article in the inaugural issue of this journal. This is an historic moment, and I hope that we all relish it, and we continue pushing for the journal to do the good work that it's already started. Today, I'm going to share with you part of the article that I'm writing called From Desegregation to Diversity Jurisprudence, Searching for the Promised Land. And I'm going to share the first part of the paper, which does an overview of the development of desegregation law, just to provide us with context for the rest of our discussion. Parents involved in Community Schools versus Seattle School Board No. 1, which was decided by the Supreme Court in 2007, requires reconsideration once again of whether desegregation remains relevant. Proponents of desegregation hope that the journey to integrated schools would be brief. But just as the biblical characters of the Old Testament wandered in the wilderness for 40 years searching for the promised land, our nation has wandered since 1954, seeking to end the continued injustices in public education caused by slavery, segregation, institutional, and individual racial subordination. The iconic Brown versus Board of Education decision stands as the high watermark in the campaign to desegregate schools as the means of providing educational opportunity for students of color to interests advanced by local school boards authorities as compelling with race discrimination. While a majority of the justices in the parents involved case agree that diversity and avoiding resegregation are compelling state interests, another majority, also with Justice Kennedy, call for further limits on local authorities to prevent racial discrimination against white students by school boards working to maintain or increase racial diversity within the school systems. The irony of the reverse roles should not escape us. In Brown, local authorities resisted integration while the court became the catalyst for desegregation. Now we find ourselves at a point where the court is a catalyst for resegregation. Now, this part of the paper will help us to get a context for where this whole journey towards desegregation started. And I'm going to start with a 1850 decision, Roberts versus City of Boston. Desegregation law developed in response to deep-seated racial prejudice, and the first legal challenge to segregated schools brought on behalf of 5-year-old Sarah Roberts proved unsuccessful. The court believed that such prejudice could not be undone by law and refused to declare the exercise of state power to create separate schools for whites and blacks was unconstitutional under their laws. Yet just as the 40-year journey to the promised land was only intended to take several days, the desegregation process, okay, can I just stop for 1 minute because I just realized that my pages are out of order. Okay. Because I'm still writing the paper. Okay, so let's start here. So with the Roberts case, Boston had established separate schools for black children in 1820 at the behest of black parents whose children could not attend the public schools on account of prejudice that existed against them. In response, plaintiffs developed arguments that would ultimately succeed in Brown. Plaintiffs argued that separate schools created a caste system in violation of equality under the state constitution. Plaintiff also argued that separate schools reinforced the social attitude that the entire black race possessed certain moral or intellectual qualities which render it proper to place them in classes by themselves. Finally, the plaintiff contended that even if facilities and curricula at the white and black schools were identical, quote, a school exclusively devoted to one class must differ in its spirit and character. The Supreme Court later adopted this spirit and character argument in Sweat versus Painter, stating that long-established majority institutions possessed intangible qualities which are incapable of objective measure, but which make for greatness. Vigorous post-Civil War efforts to integrate private and public institutions through constitutional amendments and congressional legislation were thwarted by Supreme Court decisions, namely the civil rights cases of 1883 and, of course, Plessy versus Ferguson. But the rudimentary principles of desegregation law established by the plaintiff in Roberts' pre-Equal Protection Clause decision eventually developed into a constitutional remedy for the separate but equal doctrine. The campaign to overrule the Plessy doctrine culminated in Brown, which declared the separate but equal doctrine unconstitutional in its application to compulsory public education. However, after the court's remedial command in Brown versus Board of Education 2 to desegregate with all deliberate speed, state officials and local school boards resisted the idea that the 14th Amendment required compulsory integration. In furtherance of that resistance, school boards throughout the South devised race-neutral desegregation policies intended to delay integration. Lower courts charged with enforcing Brown condoned the use of race-neutral plans, despite their obvious and intentional failure to achieve integration. 14 years after Brown won, the Supreme Court finally demanded the affirmative and race-conscious enforcement of the decision. In Green versus County School Board of New Kent County, Virginia, in 1968, the court rejected the county school board's race-neutral freedom of choice plan, which allowed students to choose where to enroll. While these plans were not per se unconstitutional, the court promised to strike down any plan that perpetuated segregation and to uphold plans intended to convert segregated school systems to unitary school systems. The court then accused the school board of the deliberate perpetuation of racially segregated schools. The justices called 11 years of delay intolerable and ordered meaningful and immediate progress. The court mandated that recalcitrant school boards fashion steps which promise realistically to convert promptly a system without a white school and a Negro school, but just schools. In Swan versus Charlotte-Mecklenburg Board of Education, decided in 1971, the court affirmed the broad scope of the federal court's remedial power to order effective remedies. This time, Justice Berger wrote to amplify guidelines for schools to follow to meet their constitutional obligation to move from dual to unitary school systems. Specifically, the court called for school boards to eliminate invidious racial distinctions which existed in transportation, supporting personnel, and extracurricular activities, as well as the maintenance of buildings and the distribution of equipment. Further, schools were instructed to pay attention to teacher assignments. In a series of contentious decisions, the court, by a bare majority, began to withdraw the authority of the federal judiciary to achieve meaningful integration of students only 3 years after the Swan versus Mecklenburg decision. The first assault on aggressive remedial measures to achieve integration began with the 1974 decision Milliken versus Bradley. Milliken severely limited the scope of the district court's equitable remedial power for the first time. Realizing that racially integrated schools could not be achieved within the largely black Detroit school system, lower courts approved a desegregation plan that included the surrounding white suburban schools. However, the Supreme Court rejected the plan as an unconstitutional exercise of remedial power by the lower courts. Excuse me. Because an interdistrict remedy that included school systems that had not practiced de jure segregation exceeded the equitable power of the federal courts. The court also held that the constitutional mandate of Brown did not call for achieving racially balanced schools. According to Milliken, the constitutional right of a Negro child is to attend a unitary school system in their district, not a racially balanced school within the system. Rather, when schools acted in good faith to eliminate the vestiges of past discrimination to the extent practicable, a court-ordered desegregation decree could be dismissed, even when racial imbalance or single-race schools persisted in a school district. Therefore, a finding of unitary status ended the local school board's legal obligation to integrate schools. Finally, Milliken rejected arguments that racial segregation in housing contributed to racial segregation in schools. The court rejected evidence which established a causal connection between state action and the creation of segregated housing. This prevented school officials from accounting for changing residential demographics in crafting desegregation plans. The post-Milliken jurisprudence of the court opened the way for hundreds of school districts to be released from court-ordered desegregation. Eventually, school boards across the country began to argue that the multitude of court-ordered local integration plans had succeeded in creating unitary systems, despite the continued existence of one-race schools. By releasing school boards from judicial supervision, the court set in motion a retreat to de facto separate but equal that Justice Souter and others warned of in later cases. As a consequence, the latest development in traditional desegregation law is the new compelling state interest of avoiding resegregation or racial isolation. The dissenters with Justice Kennedy in the Seattle-Louisville decision agreed that avoiding resegregation is a compelling state interest, which justified crafting a narrowly tailored plan to promote diversity. School boards, however, continue to struggle with how to ameliorate racial imbalance and financial inequality consistent with the due process clause, the Equal Protection Clause interest of non-minority students. Now, in the rest of my paper, I try to show that the 1995 decision of Missouri versus Jenkins stands as a turning point in the change discussion in those jurisdictions that had been under orders to desegregate, from talking about desegregation to talking about diversity. And I know Professor Johnson is going to deal with the distinction between those two, so I'll just share with you a little bit about the Missouri versus Jenkins case, and then I will conclude. The desegregation principle had come to rely heavily on evidence of a causal connection between continued practices or vestiges of discrimination and unconstitutional pre-Brown segregation laws. Therefore, challenges to the concept of causation became another basis, along with Milliken, for undoing what had been accomplished under Green and Swan. In Missouri versus Jenkins, the Supreme Court's finding of no causal connection between continued practices of segregation in Kansas City, Missouri public schools and de jure segregation made proof of causation in most cases virtually impossible, which I argue necessitated the paradigm shift to diversity. Now, Missouri versus Jenkins was an interesting case because it was probably one of a handful of cases where the court had exercised a tremendous amount of its equitable powers to craft a remedy. There's a separate Missouri versus Jenkins opinion from 1990 where the Supreme Court upheld the power of the lower courts to encourage tax increases by local school boards to fund the school desegregation plan. But 5 years later, in Missouri versus Jenkins 3, the Supreme Court began to question this causal connection. Most vociferously, Justice Thomas made the statement that there's no connection between what happened in 1954 and what was going on in 1984. So once it became apparent that school boards who...
I'm going to have to ask you to...
Oh, I'm done?
Yes.
Oh, I was looking for my 1 minute, 2 minute, okay. My moot court signs.
I gave it to you a minute ago.
Okay, all right. Well, that's basically where I wanted to stop anyway. I'll talk a little bit more about Missouri versus Jenkins during our question and answer period as we talk about this shift from discussion of desegregation to diversity. Thank you.
Thank you.
Now that we have a tough moderator, so you can just tell me when I get to 1 minute. So good morning, everyone. I want to thank the Journal for inviting me today and for organizing this panel. I think it's really wonderful to have an opportunity to discuss the important issue of educational equity. I think it's something that none of us should ever tire of discussing. I mean, the approach to this panel is, does integration still matter? And that's a fundamental question that we're dealing with, but I've just been on this pitch lately around, even apart from the issue of race, we are falling behind as a country in terms of education. We just have not invested enough resources to deal with and train workers for the kind of economy that we want to be able to sustain and keep generating. I think it should be a top priority for our country generally, and I think that the racial gap and ethnic gaps are worse, but the problem is really broader in scope. So some of what I'm saying leads from what Professor Scott was just talking about. I mean, I think a fundamental question today is, given all of the history that Professor Scott talks about, given how the Supreme Court resolved the parents involved case, which was basically to greatly limit the ability of school systems to pursue integration for race-conscious integration, where are we in terms of the issue of integration? Does it still matter? And when I ask, does it still matter, we could answer that, does it still matter for what? There are a range of purposes for which it matters. But part of my argument is that we have to ask the question of, does it still matter for fundamental issues of equity in education? And how we define that equity becomes a very sort of sticky point. If I had to give a short answer, I'd say yes and no. So the yes of why integration still matters is that we know from a lot of research that segregated schools have profound and concentrated disadvantages, that there are lots of disadvantages associated with that. And we also know that integration produces a set of both short and long-term gains in education. But the no is that integration alone, racial integration, is not sufficient to produce long-term economic gains, and that's been well studied. And the no of why integration might not still matter is that it's really hard to achieve. It's been really hard to achieve, and it's impossible. It's off the table in a number of metropolitan areas that have such degrees of residential segregation that, at least through schools, that's not going to be the way to achieve it. So that yes and no is part of how I think of the issue. The day after the parents involved decision came down that Professor Scott was just talking about, Juan Williams, who's a prominent African-American commentator, wrote a piece in the New York Times that said, with a headline, "Don't Mourn Brown." He basically said, forget about parents involved. The day of worrying about issues of integration and segregation are over. And the reason he says this is it's no longer relevant. We have current inequities in terms of education and dealing with issues like the achievement gap, but we can't explain those in terms of anything that looks like discrimination. A lot of those school systems are school systems with black mayors, they have black superintendents. It's certainly not something like discrimination. We can't cure educational deficits by just having white children sitting next to black children. This is something we have all heard before. And it's been futile. So he would take the history that Professor Scott talks about and says, well, there's just been this long battle to try to achieve integration in schools. Obviously, there were successes, mostly in the 70s. But if you look at statistics now, there's still a very substantial degree of segregation. Not just black-white, by the way. Latino segregation is among the highest. So he would say it's futile. And I think that piece, I think struck a nerve. I think it reflects views that people have. My own approach is that it's too simplistic to say this. The way in which race matters for education is not something you can easily reduce to issues of discrimination. It's a question of how race has become embedded in our society in ways that lead to structural kinds of inequities between two different groups. That's the question. So it's not about whether or not black children sit next to white children. And the perception that it is futile, I think, is also simplistic. We hear most of the bad stories. We don't hear the good integration stories. But I think it's right that if you don't make arguments for integration that depend on notions or connected to notions of what does this do for African American and minority achievement, then it's going to be a marginal issue. And it's not enough, I think, to connect it to broad sort of citizenship benefits or prejudice reduction benefits. And some people would disagree with me on that. They would think it's enough that it leads to these kinds of diversity gains where people are just interacting with other groups. I think that it may be enough for many of us, but I don't think it's enough to compel school systems or encourage school systems to adopt these kinds of programs or for anyone to put it on top of their policy agenda. But what I wanted to think about, and I'll just use the next few minutes of the talk, is to complicate the account that it is futile or it's completely disconnected from notions of equity to think about integration. Because I think it's much more complicated than it's typically represented. So, one, on the notion that integration is futile. I think that parents involved, one of the biggest tragedies of the case to me, was that it involved one of the more successful school systems in terms of its success in achieving integration. That's part of the tragedy. It involved the Jefferson County School District, which surrounds Louisville. And that Jefferson County School District, was, in Kentucky, had de jure discrimination, and after Brown, they relatively easily desegregated their schools in sort of a formal sense, but they didn't achieve any real kind of desegregation until the 70s when groups brought additional kinds of lawsuits to try to achieve desegregation. Well, Louisville was like the stories of Boston that you might have heard. People were throwing things at buses. It was an incredibly violent desegregation effort in Louisville. But then you fast forward 25 years later and you see a really integrated school district. And how that happened, I think, is very interesting, and I'll talk about that. But partly it was having these aggressive court mandates, and then it was the existence of community groups who sustained that integration at a local level through different kinds of efforts. There was also a real attempt that was innovative in Louisville, in Jefferson County, I'll talk about this, to link housing and education. So in other words, school districts that or neighborhoods that made efforts towards housing integration might be exempt from transportation, like busing, assignment policies, and things like that. But most importantly, in Louisville, the desegregation plan was metropolitan-wide, and this was true in a lot of southern areas. And so it decreased white flight, which is a lot of what undermines desegregation, because you had the city and the surrounding county. So you were able to think about integration together. You were able to do this kind of metropolitan-wide focus. So I think that, and so Louisville, Jefferson County is not the only example of that. There are other metropolitan-wide school districts, mostly in the South, that have achieved relative success, just measured in terms of did they achieve some sort of integration. So I think the second question of integration success has to do with its relationship to questions of educational equity. Does it produce gains for minority students? This is my argument, that we have to start making these arguments on this ground. And so integration has gotten a really bad rap in this domain. There's a lot of evidence that early desegregation plans didn't produce great achievement gains for Black students, and these are repeatedly cited in Thomas's concurrences and all of these desegregation cases that Professor Scott talks about. This idea that there were modest increases in math scores, no increases in reading scores. Well, I think that only tells part of the picture. So for one, a lot of these studies were based on early desegregation situations where there was a lot of in-school tracking and where the systems were very disorganized. And some of the later kinds of evidence are a little bit more promising. But they do point to something that I think legitimately people who are integration proponents have to deal with. But the other part of the equity argument is what we do know about segregated schools shows that those are schools that are going to be, it's going to be hard to achieve substantial equity for the kids who attend those schools. And almost all of the harm, and the way the harm is articulated, and the way the social science is beginning to talk about the harm, is in terms of concentrated poverty. So because of the confluence of housing and schools, segregated schools are often schools with very high poverty rates, and schools with high poverty rates have all sorts of attendant problems. And some of those have to do with just the effect of having kids who have a lot of needs being in the school. Some of it have to do with peer groups, but a lot of it have to do with more sort of things that flow with that, resources and teachers being the predominant kinds of things. So there's a lot of research suggesting that teachers, I mean, this is something you would all understand, flee from high poverty schools, that they have less qualified teachers, less well-certified teachers, all those indicators. A lot of the evidence shows that that doesn't just correlate, by the way, with socioeconomic, it correlates with race. So there's increasing evidence that high minority schools, even if they're not high poverty schools, tend to attract the worst teachers. Why is this significant? Because there are very few educational interventions that have been shown to be successful in dealing with achievement gaps, but teachers are one of them. So that's one way in which integration links to equity. The second has to do with a set of research showing long-term gains for African American students who attended integrated schools in the 70s or 80s. So long-term gains in terms of their ability to then enter integrated institutions as adults, as young adults. So more likely to have success in higher education, in schooling. A lot of that research is more qualitative, but it's very compelling on that front. And the reason why seem to link up to the idea of social capital gains. So you learn how to function in integrated settings. You meet people who have access to a lot of resources. It's what a lot of us, regardless of race, gain by going to Dukes and places like that. We learn how to navigate the systems of the elite. That's exactly what minority students gain in these integrated settings. So that might be what's leading to it. So I just want to conclude by saying that I think it's important that the issue of integration be connected to these arguments about long-term equity and short-term equity in terms of what happens in the classroom and in school settings. And not just issues of the citizenship gains. And by citizenship gains, I mean things like people learn from each other and they learn how to reduce prejudice. But having said that, I do think prejudice reduction is an important goal and is something that itself can be linked to longer term gains, right? So if people learn to live with each other better in society, it might increase their willingness. It addresses issues like residential segregation, I mean, their willingness to live with other groups. It addresses their ability to care about the other, so in ways that might have them invest in education more broadly and not just in education that serves their own interests. So, so there's not sort of a sharp divide between the issues. So with that, I'll conclude and just say that I actually do not come at this as someone who is deeply connected to issues of education. I'm really more of a person who thinks about housing, and so I think that the entry into this point is at this point around housing. There's much you can do after the parents involved decision in terms of integration in schools, but I think that the housing is the key intervention here. Thank you.
Good morning. It is a rare pleasure to be back at my alma mater. And in fact, every time I'm back, the school seems to be growing in different ways. Some of those are more visible. For example, there seems to be a new wing of the building every couple of years that I am able to be here in Durham. But as well, I think this journal represents an important step in the intellectual growth of the students. And so a much less tangible way, but no less important way that the school continues to move forward, continues to grow. And so I congratulate all of you who have put this conference together, who are putting this journal together on quite an impressive achievement. As well, I am pleased to be dedicating this paper to the late Jerome Culp. Those of you who knew him will probably understand why once you hear what I have to say. But for those who don't, he was a member of this faculty for many years. He was a professor of mine from whom I learned an incredible amount. And actually, I continue to learn from his scholarship. Now, the paper that I have is titled A New Strategy for Pursuing Racial and Ethnic Equality in Public Schools. And obviously that's a lot to accomplish in 10 minutes, so I will just give you the big picture of my big picture paper. Now, over the past 50 years, we have had school desegregation litigation and school finance litigation proceeding along the same time, both with the fundamental goal of increasing educational opportunity for students. Now, part of what we need to do going forward, I think, is change the way we frame the problem and thus change the way we frame the solution. And what I'm suggesting here is that instead of talking about race and poverty as though they are separate things, if there's racial discrimination, then we go to school deseg litigation. If there's wealth discrimination, then we go to school finance litigation. Instead of thinking about these as separate, now we need to start thinking about them as connected to one another. And in fact, this has certainly been an undercurrent in both of those strains of litigation for, again, the past 50 years. School finance cases often mention the race of the students. School deseg cases, at the beginning were very much premised on this idea that green follows white, right? Green being money and white being white students. But legally, we have not recognized the intersection of race and poverty and the effects of concentrated poverty that are borne more heavily by racial and ethnic minority students. That has very rarely been recognized as a legal harm. And as such, the legal remedies that come out of these two different areas also fail to adequately address the intersection of these two things. Now, we're 50 years, a little more than 50 after Brown versus Board, and of course we have a situation in which millions of African American and Latino children are concentrated in high poverty, racially isolated schools. These schools generally have lower test scores, higher dropout rates, less qualified teachers, generally much more challenging and generally characterized as worse learning environments, more limited curricular offerings, less parental involvement. And overall, these schools, at which millions of African American and Latino children are still concentrated, provide a lower quality of education. We've made some really impressive and substantial gains over the past 50 years, but this current situation is not acceptable to me, at least. And so I'm excited about the opportunity that this journal is focusing on in terms of moving education forward, trying to think differently, trying to change the paradigms in which we operate. Now, I've talked a bit about defining the problem, so to speak, differently in terms of really considering the intersection of race and poverty. Now, it's tempting to consider these things separately, and it's a lot easier to try and consider them separately. If I have numbers, if I am working in SPSS or Stata or some other sort of computer program, I can control for the effects of race. And I can say, and I'm isolating the effect of poverty on these students. Similarly, I can control for the effect of poverty, and I can say, well, all other things being equal, here is the effect that racial discrimination or racial segregation has on these students. I can do that in a computer program. I can't do that in real life. And so it's quite a challenge for us to try and really consider these things together. Now, two approaches, I think, can be particularly helpful to this. Now, two legal approaches. One is focusing on race-conscious school finance litigation, and the second is focusing on multi-factor socioeconomic status integration. Race-conscious school finance is really at the macro level. We are comparing districts to districts. Multi-factor socioeconomic integration is at the district level. We are looking school to school. And so I think having both of these strategies operating at the same time and really pursuing both of them as part of a comprehensive whole is an important part of addressing this situation. Now, with race-conscious school finance litigation, again, as I mentioned, race has really been the elephant in the room of most school finance litigation that has happened over the past 50 years. We've had school finance lawsuits in 46 states. Obviously, this is something that has been fairly common. But again, race is the elephant in the room. We have started to see some changes in this over the past 10 years or so. There have been changes, and there have also been substantial setbacks in terms of the legal foundations or the legal claims that individuals can pursue. For example, in these types of situations, what we're mainly talking about are disparate impact type claims. Well, Title VI was the avenue for pursuing those until that essentially was limited very significantly by the court's decision in Sandoval, which said basically there's no private right of action for pursuing those Title VI claims. However, and this is often a strategy in school finance litigation, what doesn't work at the federal level, we try again at the state. And so some states have been filling that gap and recreating those Title VI rights at the state level. Illinois has done that. And the resulting legislation is currently a basis for a race-conscious school finance litigation lawsuit. Massachusetts has proposed such legislation. It failed in the last session. It was just reintroduced. This is the sort of thing that advocates can latch onto in terms of focusing on state-level efforts to create these sort of legal foundations. Additionally, however, race-conscious school finance in some ways is coming out through intentional discrimination claims. For example, a case filed in Alabama about a year ago basically claimed that the tax policies were motivated by segregative purposes and discriminatory intent. Now, there are many objections to this, including basically the value of pursuing litigation as an avenue towards pursuing equality. But very quickly before I conclude, I want to move on to the idea of multi-factor socioeconomic integration. Why I'm talking about this as multi-factor is because I think it's very important that school districts don't just say, okay, we have our students in poverty and our students not in poverty, but that they also look at things like they look at other factors that present a much fuller picture of essentially the most disadvantaged students versus the rest of the students. And so some of those factors include things like considering how racially isolated a student's neighborhood is, the average education level of adults in that student's neighborhood, if the student is an English language learner, the educational achievement in that student's neighborhood school. So by considering more of these factors, again, we can get a much better picture of really who are the students who have these many overlapping layers of significant disadvantage. Now, also, part of the reason why I'm focusing on this is because there seems to be a widely held perception, in fact, a misperception, that socioeconomic integration leads to racial diversity. In some cases, this can happen. Wake County Schools, with which many of you are probably familiar, given that it's just around the corner. This is a significant effect in the Wake County Schools. But that grows out of the unique demographics of the Wake County School District. Because in order for poverty to substitute for race, we need a situation in which basically all or nearly all of the poor students are children of color, And in that other category, the non-poor students are white children. And in Wake, those things are unusually highly correlated, those two factors. But in most communities, those are not. So if we're looking for socioeconomic integration to produce more racial diversity, we need also to be considering many other factors as we go into that. Now, I've tried to give, again, a very big picture overview of my very big picture paper. Finally, again, I'd like to conclude with the idea that I'm excited about this opportunity to be thinking differently, to be trying to shift the focus of these discussions. And I think, again, by focusing on race and poverty and the intersection of those two things, that is one very important way in which we can move this conversation forward. Thank you.
Okay, what we're going to do now, I will give each of the panelists 1 minute to comment on anything that the other panelists said, and then I'll open it to you, assuming that now you have questions that you would like to address to the panel. So, Professor Scott.
Yes, I wanted to pick up on a point that you made, Professor Johnson, about the assumptions that underlie the disadvantage associated with segregated schools. And I think the assumption when we talk about disadvantage associated with segregated schools is that we're talking about the disadvantage to Black and Latino students. In the Brown brief, the plaintiff's lawyers made the argument that segregated white schools suffer a disadvantage. Now, that didn't make it into the Supreme Court decision, and so the stigmatic injury argument was focused on children of color. But one thing that Shifting to Diversity has done is to allow us to show that there is an advantage for white students to be educated in a diverse setting, and I think more research really needs to be done on that point. The other point I wanted to pick up on is you sort of touched on the fact that even in schools that achieved integration, at least numerically, there was a hidden problem of tracking, that Black students who were in integrated schools were tracked into non-academic programs or special ed, and that's just a whole nother issue that is raised with integration and the futility of it.
You have 15 seconds.
Okay, 15 seconds. Great paper, Kristi.
Professor Johnson.
Yes. I live in New York. I can talk fast, right? Yeah. So thank you for those comments. I think one of the questions I had in thinking about your papers, just whether or not you saw it mainly as a good or a bad that we were moving to diversity, and so partly it can be what you just said. It links well to what you just said in terms of the advantage of diversity rhetoric is that you can talk about benefits to all students on the higher education level. In the Michigan case, which that's what I did work on, higher ed affirmative action, there's a lot of data about how it benefits all students to be in environments with diversity. Scott Page, who is at Michigan, has done this work with regard to a lot of different settings about how diverse settings actually improve sort of cognitive skills and problem solving and different kinds of things. So I think there is research on that area, and the question is, for me, that's a very limited good. I think it's great, but I don't think it's going to be enough sort of in the political economy of integration to sustain it at the K through 12 level. I think you have to show benefits to minority students too. I think that's why some minority groups are not as interested in pushing for integration. And then in terms of Professor Bowman's piece, what I would really want to hear is how much you think litigation is going to make a difference in this area. So the Sheff versus O'Neill case was one in Connecticut that dealt a lot with concentrated poverty and was sort of to fill this gap between desegregation and school finance. And at the remedial level, it's been kind of mixed, its success. So the question is, what are our strategies? And to actually deal with this? And are they mostly political? Because there might be very good arguments in the public policy arena for school districts to want to reduce poverty concentration. And does litigation need to be the tool to do that?
Actually, I'll just pick up on some comments in response to your question. And whether litigation is an appropriate tool is certainly a question I take very seriously here. However, I think my answer is it is one thing to keep in our arsenal, but at the same time, there is a lot that different levels of government can be doing in terms of also providing incentives for some of these other sort of policy gains, especially with No Child Left Behind and the incredible potential consequences in a negative sense to a school district of not meeting the expectations of No Child Left Behind. There really are some important things that the federal government could do in terms of basically incentivizing school districts to engage in socioeconomic integration, to engage in reducing concentrated poverty by switching around or defining differently what students need to be doing. In terms of, instead of saying, well, it only counts if a student has achieved proficiency at the grade level. Well, if you can track your students and if you can measure growth over time, even if that student is not still yet proficient, that's the sort of incentive that could make it more likely for school districts to want to participate in some of these other policy avenues. Because I very much concur with the previous comments that a lot of this battle still needs to be fought in the public arena. This is definitely a lot of question of political will. And actually that ties into partly why I think litigation can be useful still.
15 seconds.
Thank you. There are many reasons, but in our current situation, think as well about our economic situation and think about legislators needing political cover, essentially, for making some fairly significant financial expenditures. That's not something that I think is going to be, that concern is not going to go away in the next few years.
Okay, now your chance either to comment or address a question to the panel. What? No questions? No comments? Monique, yes.
Professor Bowman, I was wondering if you think that you mentioned the multi-factors such as education level of adulthood. Are those factors like that at all correlated to socioeconomic status at all?
They are. And actually what's interesting is that even though we refer to socioeconomic status integration, if we're just focusing on whether a student is in poverty or not, that's not socioeconomic, that's just economic. And so part of what these other factors do is really make that fully a socioeconomic focus. But additionally, again, the reason why I think considering a lot of these things is so important is because we can really try and isolate our most disadvantaged students because of essentially the many layers of disadvantage that they are contending with.
Yes.
Is your litigation theory that under some state laws there's a constitutional right to integrated, either racially or economically integrated schools?
That is not my particular strategy that I'm looking at here. There are 3 state constitutions which which give some promise of saying essentially there's a right to integrated schools. But additionally, as the substantive right to education becomes more well-defined at the state level, that is something that some people are arguing, that in order to have a constitutionally adequate education, that it also must be integrated either based on poverty, race, ethnicity, or other sort of factors.
And a step on from that, if that's the case and litigation is brought and it's successful and it's found that a district isn't doing that, doesn't that put the courts in a perpetual role of oversight, unlike the desegregation litigation, where eventually you're looking at whether or not the remedy has been accomplished?
Yes or no. There could be many remedial approaches that would be taken to that sort of situation, and For one, actually, if district boundaries were redrawn, which, again, talk about political resistance, that's just a nightmare waiting to happen politically. But if that were the sort of remedy that the court decided to pursue, and that the boundaries were redrawn in a way that addressed that consideration, then it would not necessarily be something where the court had long-term oversight. Again, that's not the central claim of exactly what I'm arguing here, but that's how it could be addressed. Otherwise, it could be very much a perpetual oversight situation.
Yes.
I have a question for Professor Johnson. You said that in promoting educational equity, that you feel that the key intervention is housing. I was wondering if you could elaborate a little bit.
Yes. Well, what I was suggesting is that to promote integration, it might be that the key intervention is housing. And so part of this is because I think the battle for school integration has been undermined in part by residential segregation, and that the most successful suits or litigation were attempts to link the two. And the undermining didn't happen because of that's what the advocates wanted. I mean, that's where the Supreme Court led us in Milliken. I mean, one of the most amazing things in Justice White's concurrence in the Milliken case, he says residential segregation is caused by, its causes are unknown and unknowable. And I thought, wow, there's a lot of history about what caused residential segregation, that policies at the federal level, at the state and local level, I mean, government policies as well as private action, certainly. But that inability to link the two is a problem. And then also, you do have the problem of what people typically call white flight, right? So when people who didn't want to integrate, they would leave the school system by either they'd move out to the outer ring suburbs or ship their children to private schools. So under metropolitan-wide plans, you were less able to do that. Now, in terms of housing integration, where I think trying to figure out what to do to really deal with housing integration is a big deal. So it's not like I'm saying it's an easy answer. But I think there's so many other benefits to mixed income, racially diverse communities, including schools, and economic sustainability, and maybe even crime reduction, health benefits, that's what we should be striving for generally anyway. And so I think in an ideal way, a lot of people might want just to send their kid to their neighborhood school, and for it to be a very good neighborhood school in a diverse community. So how we get there in terms of housing, I think, involves changes at the federal level, involves a change at the state level, and those are things that people have made a range of suggestions on. I think it's a question of just political will and emphasis, and there's some indication that this will be part of policies of a new administration. There were definitely policies with regard to the Clinton administration with regard to how to, at the federal level, create better incentives for housing integration at the state and local level and deconcentration of poverty. And some of it is controversial politically, but I think there will be more moves in that direction that are promising. And then the last thing I'll just say on that is that there might be more success. Right now, levels of housing integration are actually greater than school integration, which is, I mean, that's what some of the data is suggesting, but you don't retain families. Families tend to be the least integrated. They move out when they have kids. So I think school reform strategies can link up with housing in ways that keep middle-class families in cities, for instance.
Yes.
I wonder how any of you would respond to problems of both very tightly segregated and very poor quality education in rural areas throughout much of the South, particularly in northeastern North Carolina here, but in other areas of the South, where the schools are very highly segregated, but not because the counties are segregated, because the nearest enclave of white people is 200 miles away. And what could be done through any of these strategies to help those children? Because it sounds like all we're really talking about is inner cities, which is a problem, but it's not the whole problem. There are lots of children being underserved in rural communities, and how can we address that?
Well, I'll give a few comments to start. Actually, part of what I'm talking about with this idea of race-conscious school finance litigation is often it is a situation in terms of racially isolated, concentrated poverty that is a situation that we often find in major urban areas. But at the same time, part of what I'm trying to suggest is that we develop a more nuanced understanding of essentially finance that is necessary to produce this adequate level of education. And also that, and essentially, some of it relates to some ideas that we've talked about already in terms of, there have been social science studies that have said, well, all other things equal, poverty of the schools being equal, if the minority enrollment in a school increases by about 10%, then in order to retain the same teachers with the same level of qualifications, you also need about a 10% increase in teacher pay. And when we talk about teacher quality being something that very strongly impacts the education that students receive, that's the sort of thing that we can take into account if we're looking at racially isolated districts, urban or rural, and consider those sorts of things.
Mm-hmm. I would agree that I'm not an expert on school finance litigation, but it sounds as if in the situation that you described, if there was some basis for challenging the level of funding of a minority school relative to a predominantly white school, that would be the avenue to pursue. And I say that because there's always been this tension between the idea that racial integration is a social good versus an all-black school being able to produce successful students. And so most of the school finance litigation doesn't address diversity or integration, it just addresses the quality of education. And so if you can improve the quality of education, that should allow us to move beyond this notion that a school has to be integrated in order to be successful.
Professor Johnson, last comment, and we're going to close it after this.
Oh, well, that's a lot of pressure on the last comment. Well, I mean, this is depressing because I don't know what to do about that, the situation that you just asked, other than, but if that might be a case where issues of school finance are more stark, and so that you are dealing with issues like teacher pay disparities. In the urban districts, a lot of times the school finance model doesn't work very well because they actually, per pupil expenditures are really high in urban areas. That might not be as true, and you can sort of apply a sort of straight up money analysis to attract more resources, I think, in the rural setting. But I don't think integration is going to be necessarily the answer. You're not going to get a lot of housing integration. But I guess I just would say in conclusion, in a sort of Pollyanna-ish way, that I hope people leave this feeling like these are issues that we need to work on, that we can't ignore the question of race and poverty in thinking about the educational problems that we have to deal with today. We can't just apply a lens that is sort of general, that doesn't actually think about the particular harms suffered by groups, either because of race and poverty or the confluence of race and poverty, as Professor Bowman has talked about.
Okay, on behalf of the forum, I'd like to thank the panel and to thank you for attending. Thank you.
Thank you.